And then the majority also somewhat, in my view, insultingly said, and there are other non-judicial avenues to relief. The government, the executive could do the right thing. For example, look at what happened after World War II. There were Latin Americans of Japanese descent that were abducted during World War II and placed in internment camps. And eventually the government did the right thing and gave them reparations. So maybe they'll do the same thing here for these guys too. The dissent wrote a very incisive explanation of why the application of the Reynolds bar made absolutely no sense at this juncture in the litigation to actually foreclose. If you're going to invoke Reynolds, and there may have been some sensible ways in which the privilege would legitimately arise here, there's still no reason, argued the dissent, to invoke it at the very outset. The Article 3 would believe in sort of actual cases or controversies, not giving sort of advisory opinions. We have no idea how the evidentiary issues are going to shape up here, so let's wait before we foreclose the litigation, before we dismiss the entire case. That was sort of the gist of the dissent. There was more. They also had a very incisive explanation of a narrower understanding of the Totten bar, and in particular that it's not just whenever the subject matter is sort of arguably a state secret, but let's think about what these cases really are, is where you have a plaintiff is a party to a secret agreement or is suing to solicit information that is a state secret. And the Totten bar also has never been invoked against a private party before. Here it's the government intervening in a suit against a private party to invoke the Totten bar. Anyway, the case is now, a petition for cert has been filed, was filed in December, and we're waiting to hear whether the Supreme Court will be taking up this case. In my probably 1 minute left, brief why this is a disaster. All of what this does is it assumes that the executive will self-police. Oh, this is okay because Attorney General said, really, they're only invoking this for national security. They're not invoking this to prevent embarrassment or to avoid revelations of unlawful conduct. We have seen overclassification in the past. Attorney General Griswold, who argued for non-disclosure of the Pentagon Papers, famously wrote in the late 80s that it quickly becomes apparent to any person who has considerable experience with classified materials that there is massive overclassification, and that the principal concern of the classifiers is not with national security, but rather with governmental embarrassment of one sort or another. So this is from the man who said we should not disclose the Pentagon Papers. Also interesting footnote, remember the Reynolds case involved that military aircraft? So in 1996, about 40 years after Reynolds was decided, that report was ultimately declassified. And it did not reveal any information about secret electronic equipment, but instead had what one reporter described as a horror story of incompetence, bungling, and tragic error. And yet the state secrets was successfully invoked in that case to suppress disclosure. So query what happens when the executive self-polices. I think this is a tragic abdication of the judiciary to assert its role in our constitutional system of checks and balances, and I hope, but I will just leave it at hope. It's troubling to me what the Supreme Court might do with this.
Thank you, Linda. At this time, I want to open the program up for questions and comments from the audience. If not, I can start it with a question for Linda live. Do we have one here?
Let me make a comment.
Charlie.
My name is Shelton Rhode. The general public is put out on that invitation. I wondered if it ever occurred to the organizers to actually have a person who could defend the interrogation techniques that were used. Is this law school so left-wing that it's impossible to have an honest discussion without contempt for the Bush administration and Dick Cheney?
Why don't you do it? I mean, obviously I would take that position. Why don't you defend it?
I don't want to defend torture. I I thought that what happened to Abu Ghraib was an anomaly of a group of losers. You defended one.
Yeah,
I don't think it was the policy of the government to do that.
could not be
When
more
I-
wrong.
when
You don't
I-
know, you don't know what you're talking about. You could
I
not be
know,
more
I'm
wrong.
full of it, but
You could not be more wrong. That was practiced in prisons throughout Iraq. The same exact thing, including the pictures. And it was the policy, not the work of those soldiers. It was the policy. If you read, in my book, I have the 12 interrogate reports by generals. Everyone said it was the leaders who were responsible, not the grunts, not your losers. They weren't losers, they were good American soldiers.
anyway.
Okay,
well,
thank you.
I think it's a fair question.
I think that we all
Dr. Cole would like to say-
John Yu's blog at ricochet.com.
Good.
Well, I think it's a fair question, and and I think it is important for people to recognize that with the higher levels of government, at least, no one wants to be in a position where some terrorist action happens against the country on your watch. And so people definitely, and there are real threats, no one's denying that. So the people are definitely, the president, let's say, the head of the CIA, the FBI, these people definitely have a responsibility to try to prevent atrocities from happening. There's no doubt about that. And giving them, and I don't think that, I don't think everybody is equally objective or equally in good faith about it, but that is a responsibility that they have to deal with. And I wouldn't deny that. The question to me is how you responsibly deal with it. And I don't think, at least, I don't think we'd be talking about this at all if we didn't think there was a problem that the government does have a responsibility to face. But the question is, are you willing to run? Are you willing to stick to your principles that you've established over a long period of time? How much are you willing to try to lean over backwards, not to be hysterical, and so on?
Yeah, did you like?
Well, I'll just say a word about the organization of the panel. We did contemplate, for example, inviting John Yoo to come. We did not think it would be remotely likely that he would accept, and he's had quite a bit of airtime on both the national television and in local audiences to get his views out, and we worried about having the program diverted to a defense or a condemnation of John Yoo, and we frankly could not come up with someone who we thought would have an informed view and be prepared to defend it publicly on the panel. So we're always open to suggestions from the general public as well as from the law school community as to how we can promote an informed debate. But just to invite somebody who has a different point of view, I don't think pushes the needle forward on this agenda. I think you want people who thought deeply and engaged with opposing points of view and have done the relevant work.
Okay, in the interest of time, let's open more questions, comments, people.